Well, friends, it looks like District Attorney Fani Willis is taking a shot at getting Donald Trump's Georgia State RICO case back on the trial track. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So friends, can I offer an observation as a former career prosecutor? I wouldn't underestimate District Attorney Fani Willis's resolve to see that justice is done for the crimes that Donald Trump and his co-conspirators committed to try to steal a Georgia election. District Attorney Willis just filed a motion, a long shot motion, admittedly, maybe even a Hail Mary motion. But as we all know, sometimes Hail Mary passes get caught, and they can be game changers. Let's start with the new reporting. This from the Washington Post. Headline: Fulton County prosecutors ask Georgia court to dismiss Trump appeal. And that article begins, Fulton County prosecutors asked a Georgia appellate court to dismiss Donald Trump's appeal of a state court ruling allowing District Attorney Fani Willis to continue prosecuting the 2020 election interference case against the former president and several of his allies, his co-conspirators, his co-defendants, his criminal associates. My editorial edition. In a late Wednesday filing, Donald Wakeford, an assistant Fulton County district attorney and prosecutor on the election case, asked the Georgia Court of Appeals to dismiss the appeal filed by Trump and 8 co-defendants because it was, quote, improvidently granted due to the lack of sufficient evidence. The motion points to the March 15 ruling by Fulton County Superior Court Judge Scott McAfee allowing D.A. Willis to continue prosecuting the case, arguing that McAfee made explicit factual findings that Trump and the others had not backed up their claims that Willis had a disqualifying conflict of interest. Quote, as both this court and the Supreme Court have repeatedly held, Georgia appellate courts will not disturb a trial court's factual findings on disputed issues outside of certain very rare circumstances, Wakeford wrote. When a trial court makes determinations concerning matters of credibility or evidentiary weight, reviewing courts, that is appellate courts, will not disturb those determinations unless they are flatly incorrect. The motion argues that Judge McAfee granted Trump and his co-defendants substantial leeway in gathering and submitting evidence to support claims that Willis should be removed from the case and that McAfee ultimately found they did not meet the evidentiary burden for removal. The trial court's careful and extensive evaluation of the resulting record and its utter dismissal of the central evidence proffered by the appellants forecloses any possibility of reversal, Wakeford wrote. The prosecution filing Wednesday nodded to the remote hope among those close to Willis and the district attorney's office that the appellate court could simply reject the appeal outright, potentially getting the proceedings, which have been at a standstill for months, back on track. So friends, let's look at just a short passage of D.A. Willis's new court filing. In the case of Michael Roman, David Schaefer, Robert Cheeley, Mark Meadows, Donald Trump, Kathleen Latham, Rudy Giuliani, Jeffrey Clark, and Harrison Floyd versus the state of Georgia. Donald Trump is always on the wrong side of the V, isn't he? The people of New York versus Donald Trump, the people of Georgia versus Donald Trump, the United States of America versus Donald Trump, times 2, one case in Florida, one case in D.C. This motion is captioned, Motion to Dismiss Appeal as Improvidently Granted. On May 8, 2024, this court granted appellant, meaning Donald Trump and his co-conspirators, his co-defendants. This court granted appellant's petition for interlocutory appeal in the present matter. With the case now docketed, the state of Georgia, by and through District Attorney Fani Willis, moves for the appeal to be dismissed as improvidently granted due to the lack of sufficient evidence based upon the explicit factual findings of the trial court to support the reversal of the order at issue. The order, filed in Superior Court on March 15, 2024, concerned various motions seeking to disqualify the district attorney from prosecuting appellant's pending criminal case or to dismiss said case entirely. As a basis for these motions, appellants, Trump and his co-conspirators, asserted that the district attorney had a conflict of interest in the prosecution due to her personal relationship with the special assistant district attorney appointed to oversee the case on her behalf. The problem with appellant's theory, as detailed by the trial court in its order, is that it was not supported by the actual evidence they provided. And D.A. Willis's 17-page motion goes on to really highlight two important principles of appellate litigation that she contends, and I tend to agree with her, should result in this appeal being dismissed and returned to Judge McAfee to be put back on the trial track. Those two principles of appellate litigation are, one, that only a trial court judge can make credibility determinations regarding the witnesses that testify in the motions hearing before the trial court judge, because only that judge is in a position to assess the demeanor and the mannerisms and the way the witnesses communicate and reach all important decisions about who is credible and who's not. And Judge McAfee did that and expressly included some of his credibility determinations in his findings. And then two, a closely related principle is that findings of fact, not just regarding the credibility of the witnesses, but all findings of fact made by the trial court judge are not to be disturbed on appeal. Whether or not an appellate court reading the cold transcript agrees or disagrees with the judge's findings of fact, they are not to be disturbed on appeal unless they are, here is the legal jargon, without record support. In other words, they should only be disturbed on appeal, the factual findings of the trial court judge, if there's no evidence in the record to support them, or, as Fani Willis cites in this motion, the legal standard in Georgia is if they are flatly incorrect. And they're not. Indeed, they're flatly correct. The findings that Judge McAfee entered after a lengthy evidentiary hearing in which Donald Trump and all of his criminal associates, his co-defendants, his co-conspirators, had every opportunity to present all of the evidence they wanted to present, Judge McAfee ruled there is no conflict of interest requiring D.A. Willis's removal from the case. Those facts, those findings are not only not flatly incorrect, they're completely supported by the evidence of record. Therefore, D.A. Willis filed this motion saying because there is no legal issue to resolve and because based on the principles of appellate court litigation, you can't revisit Judge McAfee's factual determinations and credibility determinations because they're amply supported by the record, there's no legal issue left for you to resolve, to rule on. Therefore, you should dismiss the appeal as, quote, improvidently granted. In other words, shouldn't even have been granted in the first place, and promptly return the case to Judge McAfee to put it back on the trial track and let's get this justice show on the road. She didn't say that last part in the motion. That's my characterization. So it may be a long shot, may even be a Hail Mary, but as I say, sometimes Hail Mary passes are caught. So we'll keep an eye on this litigation. But what I want to touch on now, sort of as the final topic in today's Justice Matters video, is something a little bit different. And it's something that is mentioned in the Washington Post reporting, and this is what I want to finish up with. The court, that is the Georgia Court of Appeals, had tentatively scheduled oral arguments for early October, but postponed them because of a conflict, according to a court spokeswoman. A new date has not even been scheduled, though it was unlikely to be before the fall if the panel of appellate court judges decides to hear oral arguments at all. A 3-judge panel selected to hear the case, made up of Judges Trenton Brown, Todd Markle, and Benjamin Land, has 2 full terms of its proceedings to issue a ruling, a period that would end in the first week of March 2025. That tentative calendar, if it holds, would almost certainly delay any Trump trial in Georgia until after the November election. So if the Georgia Appeals Court decides to set the case for oral argument, it might have a decision, let's say in March of 2025. Friends, is it any wonder District Attorney Willis is pursuing any and all legal avenues to try to get the case returned to the trial court judge so it can be put back on the trial track? This brings up an issue that drives me to distraction. The endless delay in appellate litigation. We know the system is broken. We know that nefarious litigants like Donald Trump are forever weaponizing the delay in the appellate process, trying to run out the clock on justice. And the thing is, friends, reforming that piece of a broken system would be so dang easy. It would basically just take a rules and procedures change in the appellate court practice. It doesn't take an act of Congress. The court could simply say, listen, so that we can move through this appellate issue in a timely manner, we're hereby giving the parties 2 weeks to file their legal briefs. 2 weeks after the briefs are received, we will hold oral argument, and 2 weeks from the date of oral argument, we'll issue our opinion, and it will be returned to the trial court. 2 weeks, 2 weeks, and 2 weeks. 6 weeks is not unreasonably fast to get an appeals court to resolve an issue so that the parties can pursue, a speedy trial, can pursue justice in a timely manner. Friends, there are some aspects of the system and of our institutions that are so broken and backwards and dangerous to democracy that it seems to me we ought to go about trying to reform them with things as simple as changes to the rules and the procedures. Let's pretend we care about timely justice. Let's stop letting the Donald Trumps of the world weaponize the delay to try to run out the clock on accountability. Because justice matters. I swear, friends, it almost makes me want to run for office. As always, please stay safe, please stay tuned, and I look forward to talking with you all again tomorrow.